Good day to all. I am Advocate प्रदीप शुक्ला, practicing at Bombay since 48 years. और आज एक वेरी इम्पोर्टेंट जजमेंट मैं अपलोड करने जा रहा हूँ मेरी यूट्यूब चैनल एडवोकेट प्रदीप शुक्ला में, और दैट इज़ अंडर सेक्शन 138 ऑफ नेगोशिएबल इंस्ट्रूमेंट एक्ट, जो चेक बाउंस केसेस को पॉपुलरली बोलते हैं. यहाँ फैक्स ऐसा था कि एक ट्रांजेक्शन्स के लिए द चेक वॉज इशूड फॉर 20 lakhs rupees, or it was dishonored and the complaint was filed. The accused preferred an application before the High Court for quashing the complaint because according to accused this is not maintainable and the check was not towards the discharge of any particular liability. The High Court, while considering both the argument, that's a Patna High Court, quashed the criminal complaint, and then the original complainant preferred an appeal before Supreme Court that the quashing by High Court was not proper. The Supreme Court has in detail heard both the parties. The judgment is very good judgment and very lengthy also. I'll just give some of the facts which are important for people to know, businessmen to know, and also the advocates also can take benefit of this judgment. फैक्ट्स ऐसा सुप्रीम कोर्ट में जब आर्ग्यू हुआ तो फर्स्ट ऑफ ऑल दी जो एक्यूज था उसकी तरफ से तो मेन आर्गूमेंट वॉज कि बंद हाई कोर्ट हैज़ कंसिडर्ड दिस फैक्ट्स दैट द check in question was not towards any legal liability. In that case, the Supreme Court should not interfere with this finding of the facts by the High Court. The complainant's advocate has also argued very well. Originally, the argument was on the basis that Section 138 of Negotiable Instrument Act moves with the presumption that once the check is given and disbursed, the presumption is that it was given towards one legal liability. Now, after dishonor of the check, the notice was given and ultimately the process was granted. Now, question, I will not go much into detail of the facts, but the legal position if we see, under Section 138 of Negotiable Instrument Act, what is to be considered is that prima facie whether there is a case believable that check issued was towards the legal liability. Now this presumption is already there. The Supreme Court held that without any evidence this presumption cannot be rebutted. Means just on oral submissions of the facts, one cannot think that check was not given towards the legal liability when there is a strong presumption the law provides. The Supreme Court also held that the High Court really held the decision without application of mind, considering the legal position that no criminal complaint should be quashed like this without evidence. Now, while using the power, the court did not say that the court has no power. The High Court has power to quash. But using the power to quash any criminal complaint, the High Court should be really slow enough to consider each and every point. Even there is a slightest presumption, particularly in the case of under 138, presumption is that the check was issued. And once the check was issued and it is returned dishonored, the accused cannot think of quashing without going for the trial, rebutting this presumption. Mainly on this point, the Supreme Court has also dealt in detail about these points and all. But ultimately, the Supreme Court reversed the judgment of High Court of quashing the criminal complaint without trial. Now, this is important from the point of view that trial is absolutely necessary in criminal quashing, and therefore the court should not just hurry up while putting an end to the justice. So this is very important judgment. Any person has any question or any such related matters to be discussed, they are all welcomed. I will give the citation. It is a judgment delivered on 19 December 2025 at the Supreme Court by Justice Manoj Mishra and Ujjal Byan. Now this is important because in most of the transactions, the checks are being issued and then on dishonor of the checks the complaint is lodged. So anybody has any questions, they can refer to me or go through the judgment in detail. It is self-explanatory. Thank you.